We're resuming the Commission of Inquiry. Council, if you will advise us of which matter we're continuing with today.
We're continuing claim number 39. Matter is a claim with regard into the estate of John Darrell, and it touches and concerns land which the Heron Bay Primary School occupies.
Yeah, thank you, Council. But at this time, I just want to inform commissioners and the listening public that Commissioner Benz is present online and is in a position to participate in this commission today.
Thank you very much. Morning, everyone. Could you Chairman, just advise them that they're still on the oath or affirmation that was taken?
Yes, I wish to inform witnesses that you are still on the oath or affirmation, and as you give your evidence today. Thank you.
Morning, everyone.
Morning. Morning, sir.
We had yesterday, when we took the break, we were looking at what is exhibit HG12. It is presently projected on the screen. The witness, Ms. Tiart, had begun a process of reading from the exhibit. You had read, Ms. Tiart, the document written, a response from Buckingham Palace, as also a letter written to all members of Parliament and the Senate by John N. Darrell. Now, you had indicated yesterday, and that is what exhibit HG12 speaks to. It is an advertisement which was taken out in the Mid-Ocean News. I'm just going to ask you to continue reading from that article. You had stopped reading, as I indicated, the letter to the Parliament. You have that document there?
Yes, I do. The Office of the Director of Public Prosecutions, second floor, Global House, 43 Church Street, Hamilton, HM 12, Bermuda. Should I read the telephone number?
No, you don't need
Okay.
to.
Memorandum, R reference ALD near. Please quote in all replies. To Kamisi M. Tokumbo, Director, from Anthony L. Blackman, Crown Counsel, date 8th of August, 2001, allegation of fraud by complainant, Mr. John Nathaniel Darrell. In furtherance of your request for advice on the captioned, a process of the facts is in order. The facts fall within a compass in my submission. The virtual complainant, Mr. John Nathaniel Darrell, resides at Sleepy Hollow Drive, Hamilton Parish, Bermuda. The virtual complainant's great-grandfather, Daniel Davis Darrell, owned 4 portions of real estate in Southampton Parish. On his death in 1888, the complainant's grandfather, Emilius Darrell, inherited the aforementioned 4 properties. In 1947, Emilius died and he left the property he owned, i.e. the property he inherited from Daniel Darrell, for George Wellington Darrell, the complainant's father. There is unquestionable proof of this, as notices for land tax payments were made up to 1971. It should be noted, however, that the description of the property on the land tax request forms was the estate of Emilius because 1, E.T. Richards, who was the lawyer of the complainant's father, did not convey the property into the name of the complainant's father in 1950. In my submission, this act commenced the legal problems which followed. Ownership of the properties belonging to the complainant's father is further provided by a 1956 deed, which makes references to the estate of Emilius Darrell. The last will and testament of George Wellington Darrell, the complainant's father, dated 29th of January, 1987, and duly admitted to probate on the 27th of September, 1999, showed a devise of all real estate, which was inherited from his father, Emilius Darrell, to his son, John Nathaniel Darrell. On the 6th March 1987, a voluntary conveyance was executed between George Wellington Darrell and the complainant. The conveyance confirmed that there is no Benjamin Darrell ownership and no Horace Cooper as recorded in a 1924 deed and government plans. A deed of confirmation dated 11th of September 1991, prepared by Appleby, Sperling, and Kemp, indicated that the complainant's father owned 75% of the property formerly owned by the complainant's grandfather. The virtual complainant alleges that a 20-foot piece of property at the northern end, which increased to 60 feet in width at the southern end, was misused to form the Riviera State Road to the west of his property. He further alleges that another section to the south was also misused to form lots 48 to 54 of Sunnyside Park. A plan submitted by Robert H. Clark, which appears to have been traced from a plan of 1932 prepared by Jim Dale, shows that Benjamin Darrell, who does not exist, owns property 20 feet further to the east. This was not recognized in earlier plans. What this plan did in effect, was to move the property over to the east, which facilitated the Riviera Estate Road to the west, another legal problem now created by this plan. The original 1932 plan prepared by Mr. Dale has never been produced. It is believed that this plan will show that Emilius Darrell is the owner of property to the north boundary of Lot 47 Sunnyside Park and to the west boundary of lots 40 to 47 of the Sunnyside Park. In a 1953, a plan of Sunnyside Park prepared by Wycliffe Stubble shows land owned by...
We're trying to enlarge
No problem.
what appears to make that easier to read. Chairman. You may continue.
In 1953, a plan of Sunnyside Park prepared by Wycliffe Stubble shows land owned by Mr. Darrell as being that of the colonial government. It also shows that land to the west of lots 40 to 47 of Sunnyside Park is owned by George Arnold Williams. This is not correct. A further legal problem is now created. In 1974, the Bermuda government instituted court proceedings to assert their claim to the virtual complainant's land. An area map was produced by the government, but no supporting deeds. The case went against the complainant. The effect was incorrect recognition of Sunnyside Park lots 48 to 54 and incorrect recognition of the Riviera Estate Road. This decision apparently forms the basis of the virtual complaint's concern as it exists today. In 1977, the complainant knocked down some fencing which was erected by the government and had separated his land. A court case ensued, and the then magistrate, Mr. Nataraja, ruled in favor of the complainant. The magistrate ruled that the government did not produce the appropriate documents to support ownership of the land. This ruling was contrary to that of 1974. In 1978, another court case was instituted against the complainant. A claim was made to the entire parcel of property. Success for the government would have signaled goodbye to the complainant's property. It is to be noted that the judge who determined the case, Mr. Walter Robinson, was the attorney for Sunnyside Park owners in 1953 and the attorney for the complainant's father in 1968. 63, pardon me. He, in the role of attorney in 1964, prepared a deed in favor of the complainant. However, in adjudicating the case, he decided in favor of the government. The act of determination by the judge in my submission was a clear violation of the principles of natural justice and obvious bias. It is also worthy to note that the judge ruled that the house in which the complainant resided, according to the plan of 1930 by J.H. Dole, belonged to the non-existent Benjamin Darrell. Further legal confusion. In 1979, Robert H. Clark surveyed the land. His survey showed that the portion of land allegedly owned by Benjamin Darrell, Orris Cooper, and the government was actually owned by the complainant. It further showed that the Riviera Estate Road had in fact been cut through a portion of the complainant's property. In 1982, the complainant found two plans at the Department of Planning. Both plans confirmed government ownership to the property. These plans were in conflict with all the deeds and plans which were in existence. More legal confusion. In 1983, the complainant bulldozed his personal property. Another court case followed. In 1987, the complainant blocked the Riviera State Road directly outside his residence. Another court case followed. Judge Hull heard the matter and ruled in favor of the government. His ruling was produced on 1953 Sunnyside Park subdivision, which was prepared by Wycliffe Stubble. During the period 1988 to present, the complainant's health has deteriorated. His finances have also dwindled. He still wants to fight the government. He is still of the opinion that he has been cheated out of his land. He now alleges fraud. Issue whether or not there is evidence of the criminal offense of fraud, and if so, by whom. Discussion. To defraud is to deprive by deceit. It denotes impropriety and the obtaining of property by unlawful means. The mental element of mens rea must be satisfied. Having read the documents submitted, there is nothing in my opinion to substantiate fraudulent conduct by any party. What is obvious to me is professional negligence and a blatant breach of the rules of natural justice. Professional negligence, in my opinion, occurred from 1950 when E.T. Richards, who was the attorney from the complainant's father, did not convey the property to the father of the complainant. Further, evidence can be seen in the following. A plan of 1932 submitted by Robert Clark, which showed one Benjamin Darrell who did not exist as owning property. The 1953 plan of Sunnyside Park prepared by Wycliffe Stubble, which showed the land owned by the Darrells as being owned by the colonial government, and the land to the west of the lots 40 to 47 of Sunnyside Park to be owned by George Arnold Williams. The two plans produced in 1982, which were in conflict with all plans and surveys produced up to that point, including those relied on by the court in 1974. In my submission, a clear breach of natural justice occurred in 1978 when Mr. Walter Robinson, the presiding judge, a former attorney for Sunnyside Park owners and the attorney for the complainant's father in 1963, did not remove himself from the trial. He eventually ruled against the virtual complainant. Conclusion. There is evidence of shoddy work by the professional surveyors and some attorneys. There is no doubt in my mind that the virtual complainant has been unfairly dispossessed of his land. From the documents submitted, I am of the opinion that the Riviera Estate Road does in fact pass through the complainant's property. The documents produced, and indeed the legal representation which the complainant received in the early proceedings, must also be questioned. It has so happened that the Crown was better able to prove its case, and it did so based on the documentary evidence that was available. I'm of the opinion that there has been no direct or fraudulent conduct on the part of the Crown. The problem was inconsistent and misleading documents, plans. This is indeed a civil matter. Considering the amount of litigation that has already taken place and the financial status of the complainant, I'm afraid that unless he receives some gratuitous payment or compensation, his efforts to keep what appears to be the property, were all in vain. Indeed, a sad situation when one considers the quest by the Darrells to own their share of the Little Rock and the offended individuals have all passed. Respectfully submitted, Anthony L. Blackman, Crown Counsel.
Miss Tiart or any of your family members, if I take you back just to the said document, just above the conclusion where it states, and I just wait for it to be projected. Where in this opinion that you are relying on from an internal memorandum from the Director of Public Prosecution's office, which was published in the Mid-Ocean News on Friday, October 25, 2002. The first bullet point that is shown there states that a plan of 1932 submitted by Robert Clark, which showed one Benjamin Darrell who did not exist as owning property. Now, in respect of a plan, do you have a comment or have you anything you wish to share in terms of that point that is being made, that there's documentation, somebody's name is used, but the person does not exist? Have you given any thought to that matter?
Yes, there are further documents within our presentation that speak to Benjamin Darrell, and we also have maps that map that's being communicated in this document that shows the proof of Benjamin Darrell, and later a document that I guess recuses the name of Benjamin Darrell and says that he didn't actually exist.
So I'm just going to ask you, just to repeat, the documents that you're going to draw attention to shortly, does it establish that Benjamin Darrell exists or that he does not exist?
It establishes that he does not exist.
Okay. Now, Ms. Tiart, and I know this is one that I probably shouldn't ask you, but I still would ask for the opinion. If in fact somebody's name is used and that person does not exist, do you have a view as to how that would affect the matter that you're here submitting as a claim?
I don't exactly understand your question.
If somebody says that somebody is a phantom and the person does not exist, I'm asking you whether or not you think that affects, it's somewhat a legal question, but you're submitting a claim. I just want to know if at this time, or you'd wish to wait until the submission of the other documents to share whether or not you have a view, I'll finish the question, whether or not you have a view as to what this amounts to. You'd like to answer, sir? Could you just state your name for the record so we have?
McMahon, Donald
Yes.
McMahon. I'd like to answer that there. The area where Benjamin Darrell's name is put on the plan,
Yes.
it's the same, he had a mortgage that my great-great-great-grandfather had, which is Daniel Davis Darrell. That's where his name was put on the plan, and he acquired that in 1885. And this property hasn't been sold from the time it was acquired to, he was paying tax on until 1971. So basically, that plan, this mortgage deed was up long before that even came about, that 1932 deed.
Okay. So I'm just going to ask you to repeat that for us and a little slower
Okay,
in
I'm
terms
sorry.
of what you're saying. And then I'll ask a question
Okay.
after. Just turn the microphone a little to you, please.
Okay, I'm sorry. Okay, to answer that, the area on the plan that they're describing as Benjamin Darrell's property,
Yes.
it's the same area that my grandfather, great grandfather, Daniel Davis Darrell, and his wife acquired mortgage in 1885. So basically, from looking at that, they had acquired that in December 1885, and the sons acquired it. It turned on to when he passed, it went to his son and all that there, and then on to my grandfather. So to say Benjamin Darrell acquired that in 1932 or whatever they said, and we've been paying for that from the time we acquired it up until 1971.
Okay.
From what I've seen of this here, I've noticed a lot of stuff is put a name, the last name Darrell, they'll put a name there.
Okay.
That's what I've noticed.
Okay. Thank you. And final question, but if you think it's one that unfair is a strong word, but the opinion speaks to that there is no fraud. But if somebody's name is used who does not exist, have you formed an opinion as to what that would amount to in terms of your claim?
Yeah, so we're assuming.
Just state your name for me.
Sorry, Haley Tiart. We're assuming that that may be an element of fraud.
Okay. But we'll come to the documents shortly. Now, the article said exhibit HT 12. It also has a Bermuda police report that was published in the article. I'm going to ask you also to take us through that document. It is a little long. However, what I'm going to ask you to do in the interest of time, I will take you to parts of the document. This, based on your understanding, this document, this Bermuda police document was obtained by John Darrell, correct?
Yes.
And he sought to publish and make known to everyone what was an opinion held by the police in respect of his claim.
Yes.
Okay, you may go ahead and start reading, please.
To Commissioner of Police, Division/Department, CCD. Attention from David Cart, Detective Inspector, date 5th of June, 2001. Subject, alleged fraud, John Nathaniel Darrell.
Just a minute, Council, could we have that document put up on the board so that the commission could read it?
No, that hasn't come in. Yes, that is
A part of it now appears, yes.
Yes.
Sorry, Wittens, I just wanted to get that document up so we could read it clearly.
It appears now.
It's now up, yes, thank you. Yes, you may continue, madam.
Okay. Sir, in July 2000, the complainant in this case, Mr. John Nathaniel Darrell, date of birth, 8th of January, 1938, retired stonecutter, 71. This is 6th of January. It says 8th. Yeah. Date of birth is wrong. Okay.
Yes,
It's
just
a
read,
correction.
just read
His
as
date
you
of birth
see
is
it,
wrong,
please.
but it says 8th of January, 1938, retired stonecutter, 71 Sleepy Hollow Drive, Hamilton Parish. Mr. Darrell had been directed to this office following letters sent to Her Majesty the Queen, the Governor, and the AG's chambers. He was eventually referred to the police by the DPP when the issue of fraud was raised. I met with Mr. Darrell and discussed his complaint, which appeared to me to be a purely civil matter, and I subsequently provided him with a short letter to this effect. In October 2000, the matter resurfaced, and Mr. Darrell was again referred to this office. Over the months since, Mr. Darrell has visited this office on numerous occasions, producing various documents relating to his problem and attempting to outline to me the nature of his complaint. Mr. Darrell himself concedes that a very complicated situation exists, which is not easy for any person to understand. The narrative provided below, read in conjunction with the attached documents, sums up his complaint. In 1888, the complainant's great-grandfather, Daniel Davis Darrell, died. Prior to his death in 1885, the complainant contends he was the owner of 4 adjoining portions of property in Southampton, one of which is described on page 319 in the Book of Mortgages, number 10. At the time of his death, according to the complainant, his grandfather, Emilius Darrell, inherited 4 properties, including the one previously described. The deeds to some, if not all, of these properties were once in the possession of the complainant's father, and subsequently in the possession of his father's lawyer, E.T. Richards, and should be inferred to exist based on the ownership of adjoining properties as outlined later in this report. The Darrell property is referred to in a conveyance of adjoining property from John O'Flaherty to Gaius Edmund Powell, which is dated in the 30th June 1939. At that time, Joan O'Flaherty conveyed a piece of property about 3.5 acres in size, located to the immediate west of a portion of the Darrell properties, to Mr. Powell. This document describes 3 of the properties bordering the eastern boundary of the O'Flaherty land as being owned respectively by Alice Maud Jones, Emilius Darrell, and Mr. George A. Williams. A plan attached from a 1912 deed for that area shows the land which Joan O'Flaherty owned was originally owned by H.W. Dallas, upon which was subsequently drawn the approximate position of the Bermuda Railway. But the most significant aspect of this conveyance is that it makes no mention of government's ownership of any land to the east of the O'Flaherty property in 1939. On the 22nd of December, 1959, Mr. Powell sold a piece of property amounting to some 12.5 acres to Benjamin Rigo. There are 2 schedules in that conveyancing document which describe the size of these lots as 3.58 acres and 9.04 acres respectively. The description of these lots seems to indicate that the larger section of that property was to the south of the railway land, and the smaller section was to the north of the railway land, which is confusing when comparing it to the properties which border it to the east. The second schedule of that document, relating to the larger section, indicates that its borders to the east extended for 584 feet and encompassed the land at its northeastern end, which was owned by the railway company, then by Emilius Darrell in the center and by George Arnold Williams along the southeastern end. It almost suggests that the land described in the O'Flaherty deed must overlap that described in the second schedule of the 1959 Powell conveyance. The first schedule to that document shows government ownership of a 356 feet stretch of land on the eastern boundary upon which the Heron Bay School had been built, but government have never been able to produce deeds to show their ownership of this land. The situation is even more confusing when the above documents are compared with the Marshall and Lawton Plan dated 14th of October 1959, which describes the Riviera Estates subdivision. This plan encompasses all of the property sold by Powell to Benjamin Rigo, as outlined above, plus some additional property. This plan fails to properly describe the Tribe Road, which passes through that land. The property overlaps the Tribe Road on its eastern boundary and encompasses a strip of land belonging to Mr. Darrell, upon which the Riviera Estate Road was built, which will be referred to in more detail later in this report. The complainant enlisted the services of Christopher Crisson, a local civil engineer and surveyor who studied that area extensively and who prepared a plan of that land area to show how the properties existed in 1888 when inherited by Emilius. This plan, dated the 6th of February 1995, shows the borders of each portion of property and outlines the dimensions of the portions referred to in Docs 1A and B above as being owned to the north by William Lightbourne, to the east by Foster Mallory Cooper, to the south by Joseph Francis Darrell, and formerly by Thomas Cooper, then deceased, and to the west by the Government Tribe Road. The Flaherty conveyance, he contends, fails to recognize the Tribe Road to the west, which separates the properties. The complainant also contends that the two conveyancing documents to Gaius Powell from the Pitts family describe and confirm the existence of the Tribe Road to the west of the property owned by Amelius. The approximate position of the Tribe Road is also shown on the Robert H. Clark plan received by the complainant's father in August 1953, which was allegedly copied from the J. H. Dale plan of 1932. The complainant disputes some aspects of the redrawn 1932 plan. In 1947, Amelius died and left the property he owned to the complainant's father, George Wellington Darrell. A receipt for payment of land tax confirms this, dated the 25th of October 1947, which recognizes the complainant's father as the property owner. Demand notices to the complainant's father in 1971 indicate that he was still paying land tax on the said properties, but describes the inherited property as the estate of Amelius because E.T. Richards, the complainant's father's lawyer, had failed to convey the property into the complainant's father's name in February 1950. A 1943 deed and subdivision in respect of property then in ownership of George Arnold Williams, formerly owned by Horace Cooper, 1928, and then owned by Ormond Ralph Loblian after that, shows that property to the north was owned by the estate of Joseph DeRosa and to the west by the estate of Amelius Darrell. A 1956 deed in respect of a Mr. Anthony Rebane further confirms ownership of the property belonging to the complainant's father, George Darrell, by referring to the estate of Amelius Darrell. The last will and testament of Mr. Darrell's father, dated the 29th of January, 1987, which has been probated, indicates that he leaves all of the property he owns to his son, the complainant John Darrell. A voluntary conveyance dated 5 weeks later, 6th of March 1987, prepared by Brown and Wade, confirms that there is no Benjamin Darrell ownership and there is no Horace Cooper as recorded in the 1924 deed and government plans. A deed of confirmation dated 11th September 1991, prepared by Appleby, Sperling, and Kemp, confirms his father's ownership of 75% of the property owned by his grandfather. He contends that it only reflects 75% because a slice of property measuring 20 feet at the northern end and increasing in width to 60 feet at the southern end was misused in 1962 to form the Riviera Estate Road to the west of his property. Another section of his property to the south was misused to form lots 48 to 54 of Sunnyside Park. The complainant contends that a plan prepared by Robert H. Clark, allegedly traced from a 1932 plan prepared by J. H. Dale, is false, in that it shows the property owned by Benjamin Darrell to be 20 feet further to the east than was recognized in earlier plans. The complainant contends that there was no Benjamin Darrell in existence from 1885 to date. It is not known why the name of Benjamin Darrell was introduced, perhaps by error. The land referred to on this particular plan is the complainant's land, but the net effect of this plan was to move the property over to the east, which allowed for the future development of the Riviera Estate Road to the west, an event that took place in 1962. Government cannot produce or will not produce the original 1932 J.H. Dale plan, nor will they produce the 1943 and 1953 subdivisions of that area, which he further contends will show that Amelius Darrell is the owner of property to the north boundary of Lot 47 Sunnyside Park and to the west boundary of Lot 40 to 47 of the Sunnyside Park. The 1953 plan of Sunnyside Park, prepared by Wycliffe Stubble, is accurate, except that it shows land owned by Mr. Darrell as being that of the colonial government. The land to the west of lots 40 to 47 of Sunnyside Park is also falsely represented as being owned by George Arnold Williams. In 1974, there was a court case brought by the Bermuda government to assert their claim to his father's land, and in furtherance of their case, government produced an area map, but no supporting deeds or plans. During those proceedings, government failed to justify their ownership of the colonial land as shown on the 1953 Sunnyside Park subdivision plan, but his father's lawyer in those proceedings, Ann Cartwright, failed to put forward an adequate challenge to government to produce the documents supporting the area map, which he contends was false, which resulted in the case going against his father. The effect of this case was the incorrect recognition of the Sunnyside Park, lots 48 to 54, and the incorrect recognition of the Riviera Estate Road. The complainant contends that the incorrect position reached by the court in this case was the basis of the problem which exists today, and subsequent court cases have further compounded and complicated the situation. In 1977, the complainant knocked down some fences which had been erected by the government and separated his land below the old railway right-of-way to the rear of Heron Bay School. This led to a court case in HMC with government suing the complainant for $594. When it came to trial, the Crown's prosecutor, name unknown, met with the complainant outside of magistrate's court, but knew nothing about the case and subsequently adjourned it. When the matter eventually came to trial later that year, government prosecutors dropped the amount of their claim to $55, but the complainant refused to be pacified, and a trial was held in 1978 with Mr. Nataraja as the magistrate. Once again, government failed to produce the appropriate documents to support the ownership of the land, and on this occasion, the magistrate correctly found in favor of the complainant and held that government had failed to show any right to erect a fence separating the property. In reaching his judgment, the magistrate completely ignored the decision reached by the court in 1974 case. In 1978, there was a further court case brought about by the government, Mr. Ralph Marshall, MP, Public Works and Engineering, laying claim to the entire parcel of property and leaving the Darrell family with nothing. In that case, Mr. Marshall relied on the 1953 subdivision in support of his case. The judge in that case, Mr. Walter Robinson, formerly the attorney on behalf of Sunnyside Park owners in 1953, and attorney for the complainant's father in 1968, and who had prepared 1963, and who had prepared a deed in 1964 in favor of W. Brown and the complainant, went against those earlier positions and decided in favor of the government in respect of Darrell-owned land. He ruled that the house in which the complainant was residing was his property, but the exhibits introduced in the case reflected it as belonging to Benjamin Darrell. Exhibit 10 in that case was a plan prepared by Quentin Stubble of the Public Works Department, allegedly based on the, March 1st, 1930 J.H. Dale plan, which is an incorrect document. In the same judgment, he incorrectly recognized the boundaries surrounding the lot of land on which the house was situated. Benjamin Darrell never existed and could have never owned that land. In 1979, the complainant enlisted Robert H. Clark to survey the land, which resulted in a further plan showing the portion of land allegedly owned by Benjamin Darrell, Horace Cooper, and government, as per the 1953 subdivision, was actually owned by the complainant, and that the Riviera Estate Road cut through a portion of property further to the west on the eastern side of the Tribe Road. In 1982, the complainant found two plans at the Department of Planning, one by Wycliffe Stubble in 1953, and the second was a revised version of that prepared by the Bermuda Caribbean Engineering Consultants, Ltd., in 1982, which confirms government's ownership to the property, which they should have produced in 1974. These plans were in conflict with all of the deeds and plans which were accepted by the courts as exhibits in 1978. In 1983, after years of frustration in trying to resolve his ownership, the complainant bulldozed his personal property to the west of Lot 33 and to the north of Lot 47, Sunnyside Park, in a further effort to reassert his claim to the land. And this brought about a further case instituted by government where the prosecutor, Mr. Austin Ward, now CJ, attempted to have Mr. Darrell locked up in casemates for trespassing on the land. The complainant's lawyer, Mrs. Lois Brown Evans, now AG, challenged Mr. Ward over this issue on his way court, and on his way out of court, and Mr. Ward never returned to pursue the case, leaving the matter still pending to date. In 1987, the complainant took further action by using rubble to block the Riviera Estate Road directly outside of his residence, which was his land, as supported by earlier deeds. This led to a further court case brought by government. Government failed to produce documented proof of their ownership of the Riviera Estate Road and ignored the deeds referred to on page 26 of the judgment. A letter to the complainant from the SG, Mr. Pierce, dated April 6, 2000, supports the complainant's claim to the house as accepted by the court in 1979 judgment by Walter Robinson. Judge Hull failed to acknowledge the 1945 deed that confirmed the tribe road as shown on the Robert H. Clark plan. Judge Hull also delivered a judgment on the qualifications of the government surveyor, Mr. S. Johnson, who had prepared a plan of the area for government, which was based on the 1953 Sunnyside Park subdivision, but was incorrectly revised by Mr. Subble in 1970 and further revised and relied on by BCEC in 1982, showing government's ownership to the DeRosa estate as adjacent to lots 36 and 37 of Sunnyside Park, and land adjacent to lots 47 and 48 as belonging to the colonial government. When this plan is compared with the George Arnold Williams deed of 1943, it shows that the DeRosa estate was adjacent to lots 33 or 35 of Sunnyside Park, and that the property adjacent to lots 47 and 48 was the property of Amelia Sterrell and not the colonial government. On the Stubble plan, the DeRosa estate had been moved into what is now Scenic Heights. Mr. Johnson's plan further complicated the whole issue by showing Horace Cooper's ownership to a part of the property, which he accepts was previously shown as the colonial government's. Horace Cooper only ever owned lots 1 to 47 of what became Sunnyside Park. The plan also indicates that ownership of property to the north of a portion of lot 48 and to the north of the entire lot 55 of Sunnyside Park was also owned by Horace Cooper, and gives the land to the north of his property as being land owned by the complainant. This plan is in conflict with all the deeds and government plans, but well suited government's position in the cases they brought against the complainant. In 1988, the complainant started to become ill. Back in 1962, the complainant owned his own house, which he rented. He was a mason and stone cutter by trade, and in the years that followed, built many houses. During the years from 1962 until he fell ill, he had used the proceeds from his work to support his battle for his property, but when he became ill, this source of revenue ceased. He continued to receive financial support from both banks and both financial and moral support from some members of his family and friends. Everyone, including the banks, had accepted his contention that the courts had reached their decision by reliance on misleading evidence presented by the Bermuda government. In 1989, the BNTB, Kathy Lightbourne, loan officer, viewed the various documents and agreed to provide Mr. Darrell with a loan to fight his claim to the 60 by 20 strip of property, a part of which had been swallowed up by the Riviera State Road. Over the next 2 years, the complainant's loan obligation grew to $120,000, which he had used to meet various personal debts and legal obligations. In 1990 and 1991, as collateral for that money, his brother James Darrell pledged his Hamilton Parish property. The complainant discovered that he couldn't move at that time against the property consumed by the Riviera State Road, and so he used the Robert H. Clark Plan, 1979, which had been copied from Mr. Quinton Stovall's 1970 plan. This was to provide him with a stronger position by incorporating the other parts of the Amelius Darrell property into the deed of confirmation based on the accepted voluntary conveyance of the 6th of March, 1987. In September 1991, the complainant contends that the BNTB's lawyer, Simon Farmer, Appleby, Sperling, and Kemp, did 2 favors for his friend David Summers, Bermuda Caribbean Engineering Consultants Limited, with the knowledge and support of Kathy Lightbourne. A, in the mortgage deed which Farmer prepared, he failed to reflect the complainant's western boundary extending to 100 feet, which would encompass the Riviera State Road. He showed the boundary to be only 80 feet, which complied with the plan prepared by Summers, but contradicted AS&K's very own letter of 1955, as read in conjunction with the Southampton Parish Vestry record, both of which clearly show the property extending 100 feet to the west. B, yes, no problem.
Could we just probably take a 5-minute break? She has been reading for a little while. So if we could break for 5 minutes, Chairman.
Yes, Council, you want us to adjourn
It's just for 5 minutes, just
for
to
5
allow her to-
minutes? We'll do, sir. This hearing will be adjourned
Okay.
until, I'll take 15 minutes,
Very well,
until 11:30.
very well.
Okay.
I'll go ahead and come to you. I'm sorry.